And then finally, you had a story this week about the Supreme Court finally made a decision on what it's going to do with regard to assault weapon bans. So what happened there?
Yeah, so the court declined to intervene on an emergency basis, and that part is very important. But they declined to intervene in the case against Naperville, Illinois' so-called assault weapons ban, the ban on AR-15s, AK-47s, and similar semi-automatic firearms that are commonly owned by Americans. And I believe it also has a magazine limit, 10 rounds or less. It's a sales ban. You can't sell them inside the city limits of Naperville. And this case was brought by the National Association for Gun Rights, which lost at the circuit court level, the district court level, the first level, on its request for a temporary restraining order and preliminary injunction. And then it had appealed to the Seventh Circuit Court of Appeals asking for a temporary restraining order while the appeal on merits was considered. That was denied. And so then they went up to the Supreme Court and asked for one from them, which now has been denied. But I think one of the really key things here, and I wrote a whole analysis piece about this at the Reload for members who want to check out some more details on this. But one of the key bits is that those sorts of filings, those requests to the court on an emergency basis to intervene before really even the merits have been decided at any level, actually in this case, they've really just been on the sort of temporary restraining order aspect of this, which is something that you would get before the merits are considered, and something there's a much higher bar for a judge to grant. It's very uncommon for the court to actually issue those emergency injunctions. It's very uncommon for them to even consider issuing them, to even respond to them and ask for the defendants to issue a brief. That was what made this particularly interesting in the first place, right? Which is that Amy Coney Barrett, who's the justice that oversees the Seventh Circuit, asked for Naperville to send in a brief defending its law, which implied that the court was interested in the case at the very least and may have been considering jumping in at that point. But as we see now, they decided against doing so.
Yeah. As you said, it's a pretty rare thing for a court, as you said, to jump in before the merits have even kind of worked themselves out in the lower courts, especially on an instance like this where the Supreme Court hasn't really done anything with assault weapon bans on the merits. Obviously, we've talked about before, there's some people on the court that have, but the court itself hasn't. And you've even seen this in cases where they have done something on the merits, like this. They declined to get involved in the Second Circuit case involving New York's concealed carry restrictions. And that's directly related to what they just ruled in Bruin. So if they're not going to get involved in the early stages in that instance, it's obviously going to be less likely that they're going to get involved in something they haven't even really heard yet.
Yeah. And I think that was something that we tried to emphasize when I talked to Mark Smith on the podcast a couple of weeks ago, when we talked about this exact issue, is like, these are not common things for the court to issue. I mean, it's not even common for them to consider them, right? That's why this got so much attention, is that people assume that because they were considering, or they wanted to hear about the case, that maybe they were going to jump in and do something about it. But yeah, as you noted there, recent history suggested that they probably wouldn't, because there are actually two cases in New York where this same request was made and the court denied both of those. Now, the first one, though, was even more interesting because that was Antioch, and that was the case where there's a Gun Owners of America case where the court denied the request, but Alito and Thompson wrote a concurrence, right? That sort of, it was 2 paragraphs, but it gave some insight into their thinking. And they said that in that case, the lower court, the district court, had actually blocked New York's law, right? So it's different in this than this case, because the lower court here declined to block the law. They didn't issue a temporary restraining order. Whereas in the Antioch case, they did issue one. The judge did issue one, And then it got stayed by the Second Circuit, who didn't offer up any explanation for why they were staying it and what they were going to do with the case. And they stayed a couple of cases that were related to it. And so the justices there were like, we like this lower court ruling, this district court ruling, or at least we think it was thorough. They didn't necessarily say that it was right, but they said it was thorough, which sort of implies that perhaps they think it was right. And said they don't want to step basically on the toes of the lower courts. They were denying this request out of respect for the Second Circuit and its process. But they also sort of hinted that they wanted the Second Circuit to speed things up, move things along, start explaining its thoughts on why they issued the stay and what they're going to do with this case. Because they mentioned that the Second Circuit hadn't explained themselves, and they encouraged the plaintiffs to apply again for emergency relief if the Second Circuit didn't start moving, which the Second Circuit did. And then I think that also comes into play here, because one of the key things to remember about this Naperville case is that it's not the only case in Illinois about an assault weapons ban. There's a statewide ban now that has also been challenged and is now in front of the Seventh Circuit on appeal from the government of Illinois, because the district court judge in that case had blocked the law. And the Seventh Circuit seems to have gotten the message that was sent to the Second Circuit, which is that, hey, we're going to let you do your thing. We'll let you go through this case like you would normally go through it, but you need to hurry up. And so the Seventh Circuit put this on an expedited schedule. And I think that probably had a lot to do with why the court decided not to get involved. This is a lot of tea leaf reading, right? It's a lot of the sort of reading the entrails here, because you kind of got to do that with the Supreme Court. They don't, unless they specifically tell you something, you can't really know what their thought process is. But I think, people follow the court, people who understand the court, know that them requesting that brief is unusual, and in and of itself may have sent a signal to the Seventh Circuit that, hey, the court's paying close attention to this. Right. And they were paying close attention to that New York case too. And look at where what they said there. Maybe we should do the same thing and speed up our process here as well.
That's a good point. And another point I want to emphasize is something you hammered home in your analysis piece on this, which if you're a member, you should go read, is that people shouldn't get over their skis about what this means one way or another in terms of the merits of assault weapons bans. You've seen so many public comments from, for example, the state politicians that supported Illinois' state ban, for example, saying, see, we told you that this was constitutional. Yep. The Supreme Court said so. And then you see gun rights advocates. You've seen
a number of headlines to that effect as well.
Right. And it's like, no, this has nothing to do with the merits of an assault weapon ban one way or another. So I appreciated that you put that in your members piece. And I think that's worth reiterating here, that this says nothing about how the Supreme Court actually views the merits of an assault weapon ban in terms of its constitutionality.
And I also think that it doesn't suggest that the court is not going to do anything in this front. Yeah. Because that's what you say. There's a lot of pessimism lately that I've noticed. I mean, there's always some pessimism out there in from the gun rights community on the courts, especially after the decade between Heller and Bruin, where there was a lot of the court just was not very active, and so I think there's a lot of fear from people that they're gonna be that way again, and they're just gonna let the lower courts do whatever they want, whether it comports with what they said in Bruin or not, and. I wouldn't take that away from this either. Certainly, like, it's a loss. It's not a good thing for the National Association of Gun Rights. You would, if you're a gun rights supporter, you would prefer that the court get involved at this stage and say, no, this isn't. This lower court decision is wrong, and assault weapons bans are not constitutional. That's what you'd want to happen here, but. I think the analogy I used in the piece was like, it's kind of like missing a buzzer beater at the end of the first quarter in a basketball game. Like you'd rather have it go in, but it's not the end of the game by any means.
Right.
Not even close. And I think that people will have a somewhat unrealistic idea of how fast the court operates under normal circumstances. Like it does seem like they're expediting things. And Alan Gottlieb in the earlier part of the podcast talked a little bit about this, but like it's been less than a year since Bruin. It's not that surprising that the court hasn't taken up another gun rights case already. They just put down a new standard. I think it's fairly normal for them to want to see how the lower courts percolate and how they look at this standard, what arguments they come up with, what evidence they find. That they want a fully developed case. I mean, this is generally true of all the cases they take, I think. They want there to be a fully developed record so that they can go off of that rather than jumping in halfway through proceedings, and just deciding everything themselves. I mean, that the Supreme Court is the end of the line, not the start of it.
Yeah.
Right? And so, I just don't think it says much of anything about the merits of the assault weapons ban, or really about whether or not the court is going to be aggressively pursuing new Second Amendment cases.